is this an exercise of the police power, which gives government the power to regulate land use without having to compensate owners, or is it an exercise of the takings power for which compensation is required? And we argued that it is an example of the takings power. And we did that mostly by refuting the Department of Transportation's arguments. They tried to present what they were doing as simply an ordinary, everyday case of police power regulation. They cited some specific examples of those regulations, and we showed how the MAP Act differs in very many ways. It's something that no other state does to the extent that North Carolina does. Only a handful of states have anything like the MAP Act at all, and none of them give their departments of transportation so much power and do so little to protect landowners from abuse. Furthermore, the specific statutes in North Carolina, examples of land use regulations that the Department of Transportation cited, are very different. It's one thing to give a local authority the power to impose some kinds of land use regulations and to negotiate with landowners when they come in and ask for a building permit. Local authorities are usually democratically elected. They have the information they need to weigh various options and to strike a balance between acquisition costs on the one hand and things like land use values and economic development on the other. There's all kinds of ways in which what the Department of Transportation is doing is virtually unique. So it made no sense, in our opinion, to ask the court to treat them as if they were like a local authority imposing ordinary land use regulations.